Laws inconsistent with fundamental rights. Article 13. Article 13(1) declares that all laws in force in the territory of India immediately before the commencement of this Constitution shall be void to the extent to which they are inconsistent with the provisions of Part 3 of the Constitution. Clause 2 of this article provides that the state shall not make any law which takes away or abridges the fundamental rights conferred by Part 3 of the Constitution, and any law made in contravention of fundamental rights shall, to the extent of contravention, be void. Clause 3 of this article gives the term law a very broad connotation which includes any ordinance, order, bylaw, rule, regulation, notification, custom or usage having the force of law. Thus not only the legislative enactment, but anything mentioned here can be challenged as infringing a fundamental right. Article 13 in fact provides for the judicial review of all legislations in India, past as well as future. This power has been conferred on the High Courts and the Supreme Court of India, Article 226, Article 32, which can declare a law unconstitutional if it is inconsistent with any of the provisions of Part 3 of the Constitution. Pre-Constitution laws. According to Clause 1 of Article 13, all pre-Constitution or existing laws, that is, laws which were in force immediately before the commencement of the Constitution shall be void to the extent to which they are inconsistent with fundamental rights from the date of the commencement of the Constitution. Article 13 not retrospective in effect. Article 13(1) is prospective in nature. All pre-Constitution laws inconsistent with fundamental rights will become void only after the commencement of the Constitution. They are not void ab initio. Such inconsistent law is not wiped out so far as the past acts are concerned. A declaration of invalidity by the courts will, however, be necessary to make the laws invalid. The Supreme Court in Keshava Madhav Menon v. State of Bombay, AIR 1951 observed, there is no fundamental right that a person shall not be prosecuted and punished for an offence committed before the Constitution came into force. So far as the past acts are concerned, the law exists, notwithstanding that it does not exist with respect to the future exercise of the fundamental rights. In that case, a prosecution proceeding was started against the petitioner under the Press Emergency Powers Act 1931 in respect of a pamphlet published in 1949. The present Constitution came into force during the pendency of the proceeding in the court. The appellant contended that the Act was inconsistent with the fundamental rights conferred by Article 19(1)(a) of the Constitution, hence void, and the proceeding against him could not be continued. The Supreme Court held that Article 13(1) could not apply to his case as the offence was committed before the present Constitution came into force, and therefore, the proceedings started against him in 1949 were not affected. The Supreme Court held that, as the fundamental rights became operative only on and from the date of the Constitution, the question of the inconsistency of the existing laws with those rights must arise from the date those rights came into being. The voidness of the existing law is limited to the future exercise of fundamental rights. Article 13(1) cannot be read as obliterating the entire operation of the inconsistent laws, or to wipe them out altogether from the statute book, for to do so will be to give them retrospective effect which, we have said, they do not possess. This does not mean that a discriminatory procedure laid down by a pre-Constitution Act is to be followed in respect of pending proceedings or in respect of new proceedings started in respect of pre-Constitution rights or liabilities. Though the substantive rights and liabilities acquired or accrued before the date of the Constitution remain enforceable, nobody can claim his rights and liabilities to be enforced under a particular procedure which becomes inconsistent with fundamental rights. Law and laws in force. For the purposes of Article 13, law is defined as including an ordinance, order, bylaw, regulation, notification, custom or usage having the force of law. The definition of law in this article is wider than the ordinary connotation of law which refers to enacted law or legislation. It includes even the administrative order issued by an executive officer, but does not include administrative directions or instructions issued by the government for the guidance of its officers. It does not include departmental instructions. Departmental instructions are neither law within the meaning of Article 13(3)(a), nor are procedure established by law within the meaning of Article 21. Though the term law includes all laws in force, that is, custom, usage, etc. having the force of law, personal laws of Hindus, Muslims and Christians are excluded from the definition of law for the purpose of this article. The view that the strict rule enjoined by the Smriti writers, as a result of which Sudras were considered to be incapable of entering the orders of Yati or Sannyasi, has ceased to be valid because of the fundamental rights guaranteed under Part 3 is not correct. Part 3 does not touch upon the personal laws of parties. Laws in force denote all prior and existing laws passed by the legislature or other competent authority which have not been repealed notwithstanding the fact that are not in operation wholly or in part throughout India or part thereof. The term existing law includes a wider range, such as ordinance, orders, bylaws, rules or regulations by legislature or other authorized body or person. Thus, an ordinance issued by the President under Article 123 or by the governors under Article 213, a government notification, a bylaw of a municipal body are all laws in force. The term having the force of law means rule of conduct should be called a law. It must be established that it has a force of law. Post-Constitution laws. Clause 2 of Article 13 prohibits state to make any law which takes away or abridges rights conferred by Part 3 of the Constitution. If state makes such a law, then it will be ultra vires and void to the extent of the contravention. It is stillborn law and cannot be revived by removal of the constitutional prohibition by subsequent amendment of the Constitution. Though post-Constitution laws inconsistent with fundamental rights are void from their very inception, yet a declaration by the court of their invalidity will be necessary. As distinguished from Clause 1, Clause 2 makes the inconsistent laws void ab initio, and even conviction made under such unconstitutional laws shall have to be set aside. Anything done under such a law, whether closed, completed or inchoate, will be wholly illegal, and person adversely affected by it will be entitled to relief.